In addition to the breakdown in the process of evolution and adaptation, reaching for science so often fails because science can't answer law's problems. Science can tell us how things are different and how they are the same, but it cannot tell us whether that sameness or difference should have any meaning from a legal perspective. So let me give you an example. And it comes from the difficult area of tort law, particularly understanding tort claims that have to do with pain. So many of the claims in tort have to do with the question of whether the person who is claiming actually has a legitimate level of pain. So someone with a tort claim will claim that their pain level is such they can't actually work. Now, in classic cases of illegitimate claims, the person who's claimed that he or she can't work is then caught on tape lifting groceries, driving, exercising, engaging in similar activities. So these brain scan images offer the tantalizing promise of solving that problem because they may be able to tell us whether a person is actually experiencing pain. Well, here's the problem. One can be, for example, hypnotized into experiencing pain. In that case, the brain scan would show us that the person is having a real experience in pain, but it wouldn't tell us whether that experience is something that the law would want to compensate and pay the person for. It tells us that the experience of pain is the same as what we're seeing on the screen, doesn't tell us whether that's something that we ought to recognize. So science rules may not work very well for providing answers to law's questions, but science does provide something else for us. Relying on science gives us a delightfully convenient way to avoid the problems in front of us. And in so many of the examples I look at, we use science to create what I call the illusion of reasonable resolution. It allows us to ignore the fact that we have failed to resolve anything, or it allows us to mask the preferences that are embodied in the outcome of whatever it is we have decided. Now, you might say that that doesn't sound so bad. If you can't resolve an issue, why not at least ignore it or camouflage it for a while? And the problem is that the issues remain unresolved, they're doomed to reappear, and they often appear in more intractable form because now we have to manage the additional confusions created by what we have imported in trying to mask what we haven't decided. Now, before I turn to examples from the book, I want to talk for a minute about the differences between law and science. I talk about a number of these in the book, but I want to raise a couple of key differences here. Imagine if every time the scientists figured out something about nature, nature tried to change. For example, suppose that when we figure out something about how a cell replicates, the cell says, aha, I better try another route. If that were true, science would be a very different enterprise. And yet, that is the nature of law and the nature of human beings within the legal system. So the first distinction is the contrast in the possibilities of enduring structures, which I talked about this before. The second is the problem of observational separation. As academics, we are never separate observers. It just isn't an issue of observational bias. It's an issue of observational interference. So to expand on a response that Judge Easterbrook gave when asked to comment on the process of judging, he said, "You get a very different answer if you observe rats running in their mazes than if you ask them about the experience." As academics, we are always part of the rat pack. Our comments and observations are part of the workings of the legal system itself. We are intending to shape the way the decisions are made. This, of course, is not necessarily mirrored in science. The way a scientist thinks about something probably doesn't affect the way the cell replicates itself. So these are some of the problems, some of the differences between law and science that can make it an uncomfortable fit when we try to merge the two. So let me give you examples of some of the kinds of things that I look at in the book in which law has tried to import science or export its ideas, its problems to science, and how that has failed to work. But my field is patents, and in choosing examples from the piece, I have tried to draw from as many fields as possible, but I'm far too tempted to start with an example from patents, which is so familiar to me. And this is an example of law importing science, that is reaching for scientific lines and groupings to resolve legal dilemmas. Now, as a basic matter in patent law, we don't give patents on inventions that already exist or ones that would be perfectly obvious to someone in the field. So when it comes to getting a patent on a gene or a protein, the questions include, what is the inventive thing you have to do to get this kind of a patent? How different must your work and what you create be from what is already out there? And once you get a patent on the gene, what do you actually control? How far do you reach? Now, the American Federal Circuit tried to answer a number of these difficult questions more than a decade by choosing a very simple scientific line. And they said, genes and proteins are made up of building blocks. The first person to isolate the gene or protein and tell us the sequence of those building blocks gets a gene. And then your patent covers anything with that sequence that you've identified. It's a nice, simple line. And if we have to find a grouping of what a patent will cover and will not cover, might as well use scientific categories. And the body of case law that I'm referring to has been remarkably unsuccessful and received unrelenting criticism. And the question for my purposes is, how did we get to that problem? Where did the Federal Circuit go wrong? It could be that they just picked the wrong line. Maybe if we were better scientists, we'd get it right. But I picked this example for a specific reason, because I think it demonstrates a deeper problem. The questions in this doctrinal area are, what was the nature of the problem addressed by a particular invention? What was the extent of the advancement created? And what's the significance of any differences between the advancement and later inventions? These are not questions that one can answer with a simple line. And as bad as it is to throw in a rigid line where it doesn't belong, it's particularly bad to throw in a scientific line, because the courts tend to fixate on that line as if it has some mythical powers. We forget that the scientific line is an artificial construct itself. We either don't understand or we lose sight of the assumptions within that construct. So in this example I've just given you, there's a wonderful piece that helps illuminate this. Even the notion of a gene is an artificial construct. Cells contain strands of DNA. Genes are simply locations on that strand. In other words, the idea of a gene is just a way of conceptualizing a continuous string as if it were broken into individual pieces. It's a very useful way for scientists to think about and explore a natural phenomenon. But we are assigning legal rights in those pieces, and if we lose sight of the construct and the artificiality involved, we lose the ability to ask coherently whether the scientific line fits the legal issues properly as they are unfolding in the cases. So now one can frame this in terms of abdicating, that is, having reached for a scientific solution that we don't fully understand, we just stop taking responsibility for analyzing it, challenging it, and adapting it as later cases unfold. Or one can frame it in terms of forgetting. But whether it is forgetting or abdicating, the result is a truncated legal analysis and doctrinal areas that become more confused and make less and less sense as the cases unfold. It's a legal process that doesn't work very effectively.